I just want to ask you about the right analytical framework as we think about the opinion. This is an unusual case, and as I was kind of going back and forth with your friend, we don't have a case saying that the takings clause applies in this context, and I don't think Tyler quite does say that the foreclosure itself is the taking. You've briefed it as if it is a takings clause issue as opposed to an exercise of the taxing power. Why did you make that choice, and conceptually, when does the taking happen?
So we don't think every foreclosure is necessarily a taking. We think it's going to depend on whether there is excess value in the equity of the home that exceeds the tax debt. But as to when the taking occurs, if there is excess value above the tax debt, we do think the taking occurs at the time the house is foreclosed upon, not at the time of sale, which could be a different time period.
But you might not know if there's extra value in the house, because if the government is saying so long as the sale is fairly, I mean, here there was a huge difference between the debt and the value of the house. Let's say it's a lot closer. Let's say the debt was, $90,000, and you don't know how much the house is going to get at auction. So then did you take the house at foreclosure?
It's true. Without doing this sort of sale analysis, you might not know. But that's also true, and even to a larger extent, under petitioner's test, because their test is hypothesizing a fair market sale and then reasoning from that there is excess value. All I'm saying is what you would hypothesize at that moment is just a different kind of sale. You would hypothesize a distressed property sale, and if your hypothesis is that that would result in more than the tax debt, then I think you have a good indication that there is a taking at that moment. Now, of course, the actual sale that happens is going to confirm exactly what the surplus proceeds are. But I don't think there's any real analytical problem in thinking that the taking occurs at the time of foreclosure. But I should also add that timing is going to be dependent on the laws of the jurisdiction. So here in Michigan, the judgment of foreclosure,
there was a gap.
There was a gap, and then the sale happened. Under the federal scheme, the taxpayer's right of redemption goes beyond the sale. The taxpayer has until 180 days after the sale to say that he wants to redeem the property and take it back. We would say under the federal scheme, there's no transfer of title and therefore no taking until that right of redemption expires. And that's traditionally how I think courts have understood the property rights here. The transfer of title coincides with the expiration of the right of redemption.
So the right of redemption is where the expiration of the right of redemption, it's not quite, let's see. I'm not an expert in foreclosure by any stretch, so I don't know how all these steps work. But if I'm understanding you correctly, it's not really at the moment of foreclosure, because the right of redemption might expire at a time later than that.
Exactly. And technically under Michigan law, I think there's still you have until the following March 31st or 21 days after a contested foreclosure.
So you're not really pegging it to when the government exerts control over the property. You're pegging it to when the property owner has lost any ability himself to control the property.
Correct.
Okay. Well, then that would be different. When we started talking and I said foreclosure, you are saying analytically I should be thinking of this differently.
You're right. I was using foreclosure as a sort of shorthand for the transfer of title. But you're right. As a technical matter, the judgment of foreclosure doesn't necessarily coincide with that transfer of title. But I think it's the transfer
of title that matters.
That is key. And that may vary depending on the jurisdiction.
Okay. That's helpful. Thank you.